Welcome back, everybody. We're diving into something pretty fascinating today. Article 142 of the Indian Constitution.
Yeah, it's pretty powerful stuff.
Especially, and this is what we're zeroing in on, especially how it comes up in divorce cases.
Right, because you've got the Constitution and divorce. Mm-hmm. I mean, people might be thinking, wait, how are those two even connected?
Exactly. So to get into all of this, we're using a really interesting Supreme Court judgment, Shilpa Sailesh versus Varun Sreenivasan.
Yeah, this case really lays out how Article 142 can be used, when you're looking at divorce proceedings.
Especially how it intersects with, and this is a big one, the Hindu Marriage Act from 1955.
Right, because sometimes the act doesn't quite cover all the bases,
Life gets messy.
Exactly. And this article gives the court some flexibility to kind of make things right when the existing rules just aren't enough.
It's like having a plan B for justice. So help us understand this. What exactly Article 142?
Okay, so the actual text of Article 142.1 states, and I'll quote this directly because it's important, the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it.
Complete justice. That's a pretty broad mandate, isn't it?
It is, yeah.
So is the Supreme Court basically saying they can do whatever they want in these cases?
Well, not quite. I mean, it does give them a lot of leeway, but they've also, over the years, developed some guidelines.
So there are some boundaries.
Right. It's not about tossing out the rules entirely. It's more like, okay, here's the situation, and we need to make adjustments to ensure a just outcome.
It's like having that, that override switch.
Yeah, kind of. Like a safety valve, maybe?
Yeah.
And actually, the Shilpa Sailesh judgment refers to a few other cases that help explain this further.
Oh, okay. Like what?
Well, there's the Amsitic case. Maybe you know it as the Ram Janmabhoomi temple case.
Oh, yeah, that was a big one.
Right. Well, in that judgment, the court was really clear. Article 142 lets them bridge those gaps in the existing laws so justice can be served.
So it's like they can fill in those blanks when the law doesn't quite address a specific problem.
Exactly. It's about finding solutions, even in those tricky situations. But there are still limits,
Right. They can't just go making up new laws entirely.
Well, there's this other case, Union Carbide Corporation, that clarifies that while regular laws can't restrict Article 142, the court still thinks about the bigger picture, the public policy implications.
Okay, so they can't just make decisions that would throw the whole legal system into chaos.
Right. They have to be responsible.
Makes sense.
Yeah. And then the Supreme Court Bar Association case, that emphasizes that Article 142 shouldn't be used to just totally replace existing laws. It's about ensuring fairness within those laws.
It's about smoothing out those rough edges, so to speak.
Precisely.
Okay, so we've established that Article 142 gives the Supreme Court this really unique power to deliver justice, even if it means bending the rules a bit.
Mm-hmm.
But let's bring this back to our main topic, divorce in India. How does all this powerful Article 142 stuff actually work when a marriage is breaking down?
Well, that's where things get really interesting. You see, in India, marriage is traditionally viewed as something sacred. A lifelong commitment.
Right, that till death do us part kind of thing.
Exactly. But the reality is, not all marriages last forever. And that's where the legal side comes in, specifically the Hindu Marriage Act of 1955.
Okay, so you've got tradition on one hand and then the reality of divorce on the other. How does this act handle that?
It lays out specific grounds for divorce, reasons that are legally acceptable for ending a marriage.
So like infidelity, abuse.
Exactly.
Yeah.
Things like that are all listed in Section 13 of the Act. And actually, cruelty was added as a ground back in 1976.
Interesting. So that begs the question, how has the definition of cruelty changed over time?
We'll definitely get to that a bit later. But to get back to the Act, it also allows for divorce by mutual consent. That's under Section 13B.
Okay, so that sounds pretty simple, right? Both people agree, they get divorced.
You would think so, but it's not always that easy. Even if both parties agree, the Act still mandates waiting periods.
So they can't just sign the papers and instantly go their separate ways?
Yep. There's a process, and this is where things get a little bit more complicated. There's a section 23(1)A, that requires the court to be satisfied that the person filing for divorce isn't, trying to pull a fast one.
You're trying to game the system, basically.
Right. Or unfairly disadvantaging their spouse. It's all rooted in what's called the fault theory of divorce.
So even if everyone's on board with the divorce, the court still has to make sure it's all on the up and up.
Precisely. And this is where Article 142 can sometimes come into play, because sticking strictly to the letter of the law might actually lead to an unfair outcome.
Okay, so it's like Article 142 gives the Supreme Court that power to step in and say, hold on, let's make sure justice is served here, even if it means, deviating a bit from the Hindu Marriage Act's strict procedure.
Exactly. You got it. And in the Shilpa Sailesh judgment, there are actually some really compelling examples of how this has happened in real cases.
Oh, okay. So we're going to see how this plays out in people's lives.
We are. We're going to look at how the Supreme Court has used Article 142 to navigate the complexities of divorce in India, sometimes, bending those rules to achieve what they consider a just outcome.
I'm intrigued. Let's hear about these real-life cases. All right, let's get into those real-life cases. What kind of situations are we talking about here?
Well, one example that comes to mind is Amardeep Singh v. Harveen Kaur. In this particular case, the couple, they had already been separated.
Okay.
For a long time, like way longer than the mandatory waiting period under the Hindu Marriage Act.
So they'd already been living separate lives.
Exactly. And the Supreme Court, using Article 142, decided, you know what? We're going to waive that waiting period. It was like they were saying, why drag this out any further? The marriage is over.
Right. Cut through the red tape.
Exactly. It's about being practical, But what about situations where it's not so clear cut? Like where one person wants a divorce and the other one doesn't. Does Article 142 give the court the power to just grant a divorce, even if one spouse is completely against it?
That's a good question. It feels like that would be overstepping.
Yeah, it's a tricky one for sure. And it gets right to the heart of the whole debate about Article 142 in divorce cases. Okay, so the Hindu Marriage Act, it doesn't actually list irretrievable breakdown as a grounds for divorce.
Right. I don't think I've ever heard that term used legally.
But the Shilpa Sailesh judgment, it hints that maybe, just maybe, the Supreme Court can dissolve a marriage, even if one person's objecting. It's like they're saying, look, in certain situations,
we have the power to do this.
Yeah. But of course, this raises all sorts of questions, doesn't it?
It does. I mean, some people could say, hey, isn't that the court basically creating a new ground for divorce, like rewriting the law?
It's a valid concern. And legal experts are divided on this. Some say it's overreaching, that it should be up to the legislature to change the law, not the court.
Right. Separation of powers, that whole
Yeah, exactly. But others argue that, well, the court's job is to interpret the law to make sure justice is served, even if that means adapting to the times. Like, society changes, relationships change, and the law needs to keep up.
It's a balancing act, for sure. Respecting the legal framework, but also acknowledging that sometimes things need to change.
Exactly. And sometimes, those traditional grounds for divorce, they just don't cover all the messy realities of relationships. So Article 142, it can provide that extra flexibility.
It's like a pressure valve.
Yeah, a way to release that pressure to find a solution when the normal channels are blocked. But the Shilpa Sailesh judgment makes it clear. This power, it needs to be used carefully, judiciously.
Not just willy-nilly.
Exactly. So what kind of things do they consider when making these decisions? Well, the length of the separation, that's huge. If a couple has been living apart for a long time, like say 6 years or more, it's a pretty strong sign that the marriage is probably over.
So they're looking at actions, not just words.
Right. They also want to see if there have been any attempts at reconciliation, trying to work things out. And what's the impact of the separation been on everyone involved?
Yeah.
Especially any children.
So it's not just, one person's unhappy, so divorced. They're really trying to get the whole picture.
Absolutely. They're trying to figure out, is this marriage really and truly broken beyond repair?
Okay, so Article 142, it's not just about dissolving marriages. They've also used it to handle things like property division, child custody.
Yeah, all those tricky issues that come up during a divorce. It's like this toolkit, They can pull out the right tool to address the specific needs of each case.
So they can actually create a resolution that really fits the situation, not just some one-size-fits-all approach.
Precisely. It allows them to be, I guess you could say, more creative in finding that complete justice.
Okay, so earlier we touched on the whole cruelty thing as a ground for divorce. It was added to the Hindu Marriage Act back in 76.
Right.
I'm curious, how have the courts interpreted that over time? Because, cruelty, it could be a lot of things.
That is the question, isn't it? And the courts have definitely wrestled with this one. In the early days, cruelty was often seen very narrowly, like you had to show physical violence.
So like black eyes, bruises, that sort of thing?
Exactly. But as time's gone on, that understanding has broadened. Now, it includes other forms of abuse, especially emotional and mental.
Which can be just as damaging, sometimes even more so, than physical abuse.
You're absolutely right. And the Shilpa Sailesh judgment, it mentions several cases that show this shift in thinking. Like there's this one, VDF I got from back in 93. It recognized that mental cruelty, it can be devastating, just like physical abuse, and it can be a valid ground for divorce.
So even if there's no physical violence, if you're being emotionally abused, you can still seek a divorce on the grounds of cruelty.
That's right. Which is huge because it acknowledges that harm in a marriage, it can take many forms. But here's where it gets even more interesting. Some judgments have actually suggested that irretrievable breakdown of a marriage, that itself can be a factor in deciding if cruelty has occurred.
Wait, so they're saying that a marriage that's just completely broken, no hope of fixing it, that can be a form of cruelty.
It's complicated, and the courts are still working all this out. But the idea is that being trapped in a marriage that's dead, that's loveless, it can cause real harm to both people.
Like it's cruel to keep them in that situation.
Right. It can be emotionally crushing and prevent both people from, moving on with their lives. So there's this growing recognition that divorce, it's not always about pointing fingers, blaming someone.
It's not about winning or losing.
Exactly. Sometimes it's just acknowledging that a relationship has run its course and it's time to let go. It's about allowing both people to find happiness, even if it's apart.
So it's a more compassionate approach.
I think so. And Article 142, with that whole emphasis on complete justice, it can help make that shift happen. It lets the court prioritize the well-being of everyone involved instead of being stuck in these outdated legal frameworks.
So this isn't just happening in India. Other countries are dealing with these same issues around divorce and irretrievable breakdown.
Oh, absolutely. In fact, the Shilpa Sailesh judgment, it actually mentions a UK case, Owens v. Owens. This was a landmark case from 2018.
Okay, what happened there?
Well, in Owens, the wife, she wanted a divorce, said her husband's behavior was unreasonable. But UK law at the time is said she had to prove that his behavior was so bad she couldn't reasonably be expected to live with him anymore.
That's a pretty high bar to clear.
It is, and it's kind of similar to that cruelty provision in the Hindu Marriage Act,
Okay, I see the parallel. So what happened in Owens?
The lower courts, they actually rejected her petition, even though they all agreed the marriage was over. They said she hadn't proven his behavior was bad enough.
So even though the marriage was dead, she was trapped because of a technicality.
It's kind of crazy, right? The case eventually went all the way to the UK Supreme Court.
Wow.
They ended up upholding the lower court's decision.
Oh, wow.
But the whole thing, it ignited this huge debate about fault-based divorce laws. People were saying they were outdated, causing unnecessary pain and conflict. So you see, this struggle to balance the law with, the messy reality of relationships, it's happening everywhere.
It's a universal issue.
Absolutely. Yeah. And this whole debate about irretrievable breakdown as a grounds for divorce, it's going on in legal circles around the world.
Because sometimes a marriage just doesn't work out, and it's not about who's to blame.
Exactly. And forcing people to stay legally bound when the emotional connection is gone, it doesn't benefit anyone. So in those situations, Article 142 and that idea of complete justice, it can be crucial. It's like a safety valve, a way for the court to step in and say, this isn't working. Let's find a resolution that reflects reality.
We've covered a lot of ground here. It's fascinating how these legal principles and these real-life stories, they all intertwine.
They do, don't they? Because these aren't just abstract concepts. They're affecting real people going through some of the toughest times in their lives.
Absolutely. So before we wrap up, let's bring it back to our listener. If someone's going through a divorce right now in India, what are the key things they should know about Article 142? So much great information. If our listener is going through a divorce in India, what are the key things they should keep in mind about Article 142?
Here's the takeaway. If you're in a situation where your marriage has truly, and I mean irretrievably broken down, and the standard divorce process, it's just not providing a solution. Well, Article 142, it offers a potential path forward. It gives the Supreme Court that ability to step in to create a resolution that's actually tailored to your specific circumstances.
But it's not a guaranteed thing, right?
Right. Exactly. There's no guarantee that the Supreme Court's just going to grant a divorce because you ask for it.
So it's not like this magic wand you wave and poof, you're divorced.
Nope. The court, they have to be convinced that the marriage is really beyond repair, that you've tried everything else. So it's important to to approach this with realistic expectations and to talk to an experienced lawyer, someone who can help you present a strong case.
Solid advice. And, we've talked a lot about the legal side of things, but divorce, it's not just a legal process, is it? It's intensely personal.
It is. It's an emotional roller coaster no matter what the legal outcome is. So it's really important to take care of yourself during this time.
Self-care is so important.
It is. Lean on your support system, your friends, your family, maybe a therapist. Remember, you're not alone in this. And it's okay to ask for help.
Sometimes just talking to someone who gets it, that can make all the difference.
Absolutely. And if you're the spouse who doesn't want the divorce, it's equally important to understand your rights, your options. Don't be afraid to speak up, to advocate for yourself. Get legal counsel to make sure your interests are protected.
Don't just go along with whatever the other side's proposing.
Exactly. Make your voice heard. Even in the middle of all the challenges of a divorce, try to keep communication respectful. Aim for a resolution that feels fair to everyone.
Easier said than done sometimes, but it's a good goal to strive for.
It is. If you can focus on fairness, open communication, it can hopefully lessen the emotional toll and make the whole transition a bit smoother.
Well said. I think we've really delved into the depths of this topic. We've explored a lot.
We have. From the specifics of Article 142 to, the human stories behind all of this, it's been quite a journey. We've seen how this article is not just some legal thing. It reflects how our views on marriage, on divorce, how those are changing.
Right. It shows how the law is trying to adapt to those changes, to the realities of people's lives.
It really highlights that back and forth between the law and society. Our understanding of relationships evolves, and the legal frameworks, they have to evolve too.
It's a process. Okay, before we sign off, I want to leave our listeners with something to think about. What could be the bigger impact, good and bad, of the Supreme Court essentially, creating this new avenue for divorce through how they're interpreting Article 142?
That is a fantastic question, and it's one that's going to keep legal experts and policymakers talking for a long time, I think.
Definitely something to keep an eye on. But for now, we'll leave you to ponder that. Thanks for joining us on this deep dive.
It's been my pleasure. Really enjoyed exploring this complex, important topic with you.
Until next time, everyone, stay curious and remember, the law, it's always changing, and we'll be here to help you make sense of it all.